All rise, please. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Valley Horatius, Justice of Superior Court, now sitting in Woburn, within and for the County of Middlesex, of the civil business in the B session, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Please be seated. Court is now in session.
Good morning, Your Honor.
Good morning, ma'am.
May I proceed with today's list?
Yes, please.
First on our docket is docket number 1881 CV 2385, City of Waltham versus the trustees of the Stigmatine Fathers. Could parties please identify themselves for the record?
Attorney John Cerrone, City Solicitor for the Plaintiff, City of Waltham.
Good morning.
Attorney Jason Scopa with Attorney Peter Flynn on behalf of the Stigmatine Fathers.
Good morning.
Yes, Your Honor, and back in the courtroom is Father Adam, is Adam Tapp, he's also co-counsel.
Thank you. All right. Welcome to all counsel. Welcome to everyone in the courtroom. So I did see two motions in limine. Why don't we deal with those first? So I will hear from you from the City of Waltham first, please.
Your Honor, again, and I understood this to be the case, but to me, the scope of the existing order from Judge Rule 9618 defines what we're here for today as far as I understood. And and I'll address it in terms of the motion to quash. Just in terms of that, there was a subpoena sent out for the mayor yesterday, and again, the dispatcher's case, which was clearly affirmed in the Moscow versus Boston Redevelopment Authority, says none of that evidence is even admissible. That's why in Moscow they just dismissed the whole case. It's absolutely prohibited from trying to get people who were involved in any aspect of the taking to be questioned about motives or anything else. It's part of what is the essential part of executive discretion, and to quote both Moscow and dispatchers, if we were to allow public officials to be called to testify and questioned about every reason why and how and what they went into, we'd really be getting into about 3 years of a legislative and executive process. This court, if every taking were to be handled in such a fashion, it would probably have to be a court that would just handle taking cases. I think, at least as to the motion to quash, that's clear that based on both those cases, they prohibited officials from being called to testify in those circumstances.
Thank you. And I did read those cases this morning when I got the motion. So let me hear from defense counsel. How do you get around those two cases?
I have no intention of asking the mayor questions with regard to any of that would even come close to that area of inquiry. These are agreed upon exhibits. The mayor wrote a letter to my client, actually to the city council, in February of 2017, stating that according to the public records, meaning the census records she identifies, there are 8 priests residing at the campus in question. The city is hanging their hat on trying to establish that there aren't enough priests, aren't enough residential units on the premises to trigger a relocation plan. The mayor herself is on record the year before the taking as saying 8 of them live there. Second agreed exhibit the mayor authored herself and signed is a letter in 2018, about 60 days after the taking, offering the Stigmatine Fathers relocation and explaining that to them how it would work. First of all, that's after the taking, which is a problem statutorily. Second of all, the other thing they're hanging their hat on is the argument that there's no entitlement to relocation here. I can't imagine 2 letters authored by the mayor herself that go more to the heart of why Your Honor has us here today.
So is it possible to stipulate to the authenticity of those documents so they can come into evidence without the mayor herself needing to authenticate them?
I expected you to say that, Your Honor, and I was open to that initially, and then I started reading the city's answers to interrogatories, also signed by the mayor. She makes a number of statements in there. At the top of the list would be in a question about why relocation wasn't being effectuated timely or properly. The mayor says, we gave them, this is in her answer to interrogatory, I believe it's number 14, we gave them a choice between staying there after we took the property and getting the relocation rights they have coming under Chapter 79A. They wanted to stay there late, that was their choice, so they don't get Chapter 79A relocation rights anymore. Your Honor, that is a remarkable admission against her interest. It's dead wrong. It's one more statutory violation, and she should have to take the stand and answer questions about these. The Judge Lou order that you're having us here to consider further is about access and displacement. And obviously, we talk about relocation, not in something that goes before the Relocation Bureau, but simply to the point that the statute says a relocation plan has to be in place before displacement. The mayor should have to take the stand to answer for these statements. She can answer for the other stuff later.
All right, and I just want to make sure, I think we talked about this last time, but as far as you're aware, there's no case that holds the failure to follow the procedure in 79A invalidates the taking under 79, is that right?
There absolutely is, Your Honor. I think I cited many of them when I first filed my opposition. They go on and on and on about if the violations of the statute go to the general mandate, if they violate the general mandate of what's going on, they can rise to the point where you can void the taking.
I've read the cases that you're talking about. I read them a little bit differently, but why don't I hear from the city? What's your position on them, what the cases say about whether this kind of...
Your Honor is absolutely correct. And in fact, I've read almost every case that they cite is a urban renewal case, which has a whole additional set of requirements. That's why it's always talked about. The only case that's a pure 79 case is Radway versus Town of Dennis, and it actually is a very simple case, and there's only a couple of cases, and they always deal with this. It's the requirement that the taking be recorded within 30 days. It's palpably simple. It's the only really clear requirement in Chapter 79. And those are the only cases that are pure 79 cases, despite how they want to pull out dicta or whatever. The holding is simply, the town did not get order of taking on record within the 30 days, therefore it's not valid. It's not an issue here. And I also, that brings me to the second, all the arguments bring me to the second motion to eliminate, which is relocation clearly under 7 subsection B of 79A, the separate statute. Basically, that whole statute, it's not that long, creates an administrative procedure for them to be allowed to get into any of those aspects without filing claims with the bureau established under Chapter 79A would be just to rewrite that statute and absolutely ignore the requirement in subsection 79(7)B that says everything has to be brought before the Bureau of Relocation. Any party aggrieved has to go to the Bureau of Relocation, and their decisions shall be final. There is no way. What they're trying to do would rewrite all of the horror about exhausting administrative remedies for them to be allowed to do this. So the questions about relocation are questions that the Bureau is statutorily given the jurisdiction, the sole jurisdiction to deal with. And I also point out, none of them, you are absolutely correct, there's not a case that says that even if there is arguendo a violation of Chapter 79A, there's nothing that says that can constitute an attack on the validity of a Chapter 79 taking. And in fact, and I actually copied most of 79A, if you look at all of the remedies, it's only about payments. There is no right to try to get, if they're trying to seek what they're looking for is equitable relief. Despite what Judge Lou's order said after November 23rd, they should be able to stay there. There's nothing in Chapter 79A gives plenty of benefits for payments. There is no remedy specified in 29A or the statutes that changes that. So it can be handled with damages. They just keep claiming more and more.
Okay, here's what I'm going to do. For the purpose of this hearing, I'm going to allow the motion to eliminate, so that is quashed as to the mayor's appearance. You can certainly put in evidence of the documents if you would like to save your rights for appeal, if you would like. And the documents can come in if you would like them to. But for purposes of this hearing, we're going to focus on Judge Liu's order and whether it has been followed or not. I see that there are a number of items that both sides have asked me to rule on. As I see it, it really falls into two categories, permissibly that we can be discussing at this point and taking evidence on. And that is regarding basically the date of the notice to vacate or a date of notice to leave, however you want to term that. I think displacement is the term that's used in the statute, but the displacement date. And then also the reasonable access up to that point. I understand that there are many subsidiary issues under each of those, and I have a lot of evidence that the parties have already submitted, but in terms of this evidentiary hearing, if you'd like me to hear from witnesses that either deal with the date of displacement, the date of notice, or reasonable access, that's how I'd like to conduct today's hearing. And yes, would you like to be heard?
Thank you, Your Honor. So I want to be clear on your ruling on the motions eliminate, because my brother went into a second motion, which was the motion to exclude anything related to Chapter 79A and relocation. But as I understand it, Your Honor, when you say you're allowing his motion eliminate, you just mean is to quash the mayor's subpoena.
Correct.
Okay.
And now we can talk about the other one, which does relate in some ways, but
Right.
I'll hear you separately on that.
Okay. I think Mr. Savone misunderstands why relocation is so central to the issue that we're here for today and so central to Judge Liu's order.
And I understand, you're trying to say that the taking is void, and so therefore that there's no need to comply.
No, and that may be our eventual argument if we're here on motions for judgment on the pleadings or some dispositive motion later. But for today, the importance is Judge Liu's comment that the city, as of November 23rd, 2018, would have the right to displace the occupants was mistaken because it didn't go on. And in his defense, this issue wasn't before him. There was no reason for him to look further than the 120-day part of the statute. The rest of the statute provides that a relocation plan must be in play before you can displace anybody. And that was something that Judge Liu was never presented with. It wasn't briefed. It wasn't on the table that day. We're not trying to raise Chapter 79A to talk about the payment issues, the challenge to payment, which I agree with Mr. Savone. When you talk about disputes as to payments being made under relocation, that goes to the Bureau. That has nothing to do with the relocation issue today. It's very simple, the relocation issue today. You can't displace people, and Judge Liu this wasn't before. You can't displace people before you give them the relocation plan that defines how they're going to get displaced and relocated. Whether or not that voids the taking is an argument that will certainly come down the road, but for today, it goes to the heart of Judge Liu's order and why it wasn't on point to say the city has any right to displace anybody back in November or at any time before the Bureau of Relocation approves the plan to move the Stigmatine fathers.
So here's what I'm going to do on that issue. I will let you present evidence of plans, because I think it does relate to the date of notice of displacement. And so for that purpose, I'm going to let you present evidence. I'll decide, I'll read everything and I'll take everything into consideration and I'll make a determination, but I will let you put in that evidence about date of displacement and what could have happened, in addition to what has happened. For example, if there were conversations between the parties about whether or not to enter into a displacement program or not. Because I do think that relates to the date of displacement and the date of notice to vacate.
Thank you, Your Honor.
Okay.
And if I may, Your Honor, there is an assumption, and it's a huge one, that is unwarranted. There only needs to be a plan. Even under all the statutes they talk about, and it's funny how they talk about 79A like it's part of 79 and it's not.
I understand. I do understand.
So there is a requirement in 79A for us to be required to have a plan. There needs to be more than 5. That means there needs to be six separate independent dwelling units or businesses. What we have is a single housekeeping unit in St. Joseph's Hall with, in the admissions, they say 3 to 4 priests live there. There's one unit. They say they have a provincial house office and gift shop. There's a second. And they have an espousal center where they claim they conduct businesses. But I have requested documents for anything that would indicate what, if any, activity was really there. I never received one document.
Okay, and
So that if there's less than 6, We don't have to file a plan.
So what I'm gonna let both of you do is put in evidence the relevant time periods of when different people lived there, how many units that there were, all of that. So that's part of the evidence you're hearing that I'm perfectly happy to hear.
Thank you, Your Honor. I just want to note my objection to allowing the original motion in limine about quashing the mayor's.
Yes,
Thank
okay,
you.
that's noted. All right, and so plaintiffs, would you like to begin first?
Yes, thank you, Your Honor. Can you call Lorraine Finnegan, please?
Just raise your right hand and face the front, please.
Do you solemnly swear the testimony you should give the court in the case now in hearing should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be seated.
Just right here. Just make sure you keep your voice up, okay? Sure. And you can adjust the microphone any way you need to. Thank you.
And could you state your name for the record and spell your last name, please?
My name is Lorraine Finnegan, Finnegan.
Thank you.
Could you tell the court your professional qualifications and current professional location?
Sure. I'm a registered architect in the state of Massachusetts. I work for a company called SMMA in Cambridge, Mass. I work as a project manager and I am the director of the K-12 studio. So I manage all of the K-12 design and construction projects in our office.
And you have a special, I know you're an architect, do you have a specialization that you have had for a period of time within your field generally of architecture?
Yes. I have focused on K-12 school designs for the past 20 years at SMMA.
And does SMMA, which I understand is Sims Maney McKee, have a specialization also as an architectural firm?
Actually, we have 6 studios within our firm. We have, it's broken into 2 umbrellas. We have our corporate and commercial studio and institutional studio. I am part of the institutional studio under which we do government work. We do institutional work such as K-12, and we do higher ed work for colleges and universities. Our corporate and commercial group also does life sciences, corporate clients, and high tech.
And are you a principal in the firm SMMA?
I'm a vice president and a principal.
How many, in the 20 years experience that you've had working with K-12 school construction projects, how many high schools have you been involved in as the lead architect?
Either as the lead architect or involved in, as I've moved my way up the ranks, it's been different.
Okay.
In all, I've probably worked on 10 of the high schools, of the 25 high schools SMMA has done.
And with regard to the city of Waltham, can you describe what your activities are now in that context with the city of Waltham?
Yep. I am the lead project manager. I am responsible for coordinating the entire design team, including all of our specialty consultants who may or may not work at SMMA. I coordinate directly on a day-to-day with the city of Waltham, with the mayor, with the superintendent, with the school, with the users as part of the high school project, with the city solicitor as need be.
And when you say the high school project, are you talking, can you describe, is it an existing high school or were you talking about a new high school?
So as the city was awarded the city was entered into a program with the MSBA, a core program, to investigate either renovation, replacement, or addition renovation of the high school. So at this point in time, it has been determined it would be a new high school.
And did, in your functions working with the city of Waltham and its school committee and its school building committee, is there a location that you have proceeded to design and start work on for the new high school?
Yes, the new high school will be located at 554 Lexington Street.
And have you been to that site many times?
Many times.
And can you tell us, you mentioned MSBA, can you tell us and explain to the court what the nexus is with projects such as a new high school and MSBA?
Sure. So maybe just a little background. The MSBA is the Massachusetts School Building Authority. They are a quasi-governmental agency. It is a grant program, not an entitlement program. So they take 1 cent on the sales tax and they appropriate that money to cities and towns who are successful in getting a school project awarded through them. and they give a percentage of reimbursement to those cities and towns based upon different factors for that city and town: poverty level, wealth factor, percentage of free and school lunches. And they have a very rigid and prescriptive program at which we must move through various phases of study and design, construction, and closeout for a project, all the way through the end to auditing. The process from once you submit can take anywhere up to 7 years, from when you start to when you actually finish the project and finish the audit process. And it is all based on 963 CMR standards that were promulgated. And their guidelines are all on their website, and they have different modules with different requirements for each step of our design and construction phase.
What's a project funding agreement with MSBA?
It is a contract in which the MSBA guarantees a set amount. Let me rephrase that, there's no guarantee. It is a contract under which the city signs with the MSBA for up to a maximum amount of a grant that the MSBA will fund the portion of the project.
And is there currently a project funding agreement between the city of Waltham and the MSBA?
Technically, no. There is a feasibility study agreement in place at this time.
Okay, and could you describe what that is in the context of this process?
Sure. So every project starts in a study phase. It's called a feasibility study, and that contains 2 phases of the project. Feasibility, where you examine multiple different options, and schematic design, where you take one preferred option to a higher level of design and conceptual analysis and investigation. During that portion of the contract, the MSBA and the city have what's called a feasibility study agreement. It is not a guarantee of future funding of a project. It's not a guarantee of future approval. The project funding agreement is when the MSBA and the city or town has voted to approve the project and to fund the project. Then that contract is entered into between the city or town and the MSBA.
Can you tell us what the current requirements and deadline constraints are under the feasibility study agreement between the city and MSBA for the new high school project that you're running?
The current agreement for the feasibility study agreement expires on October 31st, 2019.
And are there important dates with relation to that?
Absolutely.
And can you, let me ask you another question.
Your Honor, I understood we were trying to get Judge Liu's ruling about access and dates of displacement.
This is the first witness, so this is helpful. I think that the facts of this are going to be helpful,
Okay.
but after the first witness, it usually goes a little bit quicker.
Thank you.
What is MSBA Project Advisory number 45?
So I can explain the advisory. It might be beneficial to maybe explain what advisories are.
Okay.
So when the regulations were written, 963 CMR in 2004, many detailed factors were not considered. And as the MSBA has started their process since 2004, items have arisen that were not defined within the statute. So in order for the MSBA to give guidance to architects, designers, cities and towns on how to deal with certain factors, they issue what's called project advisories. They currently have 58 project advisories that range in everything from STEM classrooms and how they should be factored in, which are not written into the guidelines, versus Project Advisory 45, which is how to deal with land issues, including but not limited to Article 97, eminent domain, easements, and those sort of things. So it defines how you deal with a project and what the processes and steps are, and what the steps you cannot proceed with until certain things are in place.
And in the context of this new high school, has the MSBA, excuse me, may I approach the witness with
Yes.
It's Exhibit 4 in the agreed list. I have a separate one for the clerk.
Oh, isn't it?
Yeah.
Attorney Savoni, it's in the pile though you gave him, right?
It is, but instead of having to
Okay.
go through it,
Thank you.
do you need a minute to review that?
No, I opened my version, which I have.
Okay, thank you. When you've been dealing with the MSBA, whether it's at hearings and other meetings, Has there ever been any discussion about the project, the MSB requirement in Project Advisory 45 in the context of letters sent to the MSBA by Attorney Flynn?
Yes, we have, during the feasibility study process, we have what's called a facility assessment subcommittee presentation, at which we need to present to members of the MSBA board and MSBA staff a presentation that overviews the project, talks about what the project is about, the educational plan, the goals for the project. During that meeting, we were asked, have we analyzed Project Advisory 45, how the project stands in relation to that, because they had received some correspondence from Attorney Flynn, and we needed to respond.
And I believe that that part of the order is not being challenged, that's not at stake here, is that right?
Yes, my understanding, the Judge Lou's orders said that we were free to communicate with the MSBA, and
Right.
and that's
Oh,
not
I
an
don't-
issue today.
right.
Okay, all right, just want to make sure, we don't have to go into any detail on that then.
Thank you.
Thank you.
And has the MSBA issued any requirements with respect to the issue about control over the site in the context of those letters?
Absolutely. We have 4 to 5 correspondence from the MSBA detailing that we must have full control, access, and ownership of the property before we can enter into a project scope and budget agreement.
So if the MSBA doesn't believe we have exclusive use, control, and possession of the site, will they go forward and approve you in the current phase in the feasibility study and allow you to get to the project funding agreement?
They will not allow us to proceed to a project funding agreement.
Council, could you please walk through those dates and just go backwards through them? I heard the October 31st date, but I believe there's some earlier dates. Can you just go
Yeah.
through those?
Yes, I'm sorry, I probably should have stuck with that, I apologize.
Yeah.
Now, in the context of, and I'm gonna, as we were talking about, bring it, focus on the current, strike that please. Did something happen with the MSBA in terms of their requirements and timelines and deadlines in this past February?
This past February, we were approved to proceed into schematic design.
And can you tell us what the deadlines are for you between now and this, in order to make and meet the MSBA's stated guidelines? And feel free to go through them and articulate what you feel from the MSBA's requirements, the particular deadline or important dates are.
Sure. So the MSBA has set calendar dates on which we can submit schematic design. It's approximately 2 months before each board meeting, and the MSBA board meets every 2 months. So in order to be on an agenda for an MSBA board meeting, we need to submit in advance of that per the prescriptive dates required by the MSBA. That allows their staff to review it, to ask questions, give us comments, see if additional information is needed so that they can make a recommendation to the board. For our project, as part of our extension letter, we are submitting on July 10th our schematic design submittal for the August 28th MSBA board meeting. In order for us as designers and engineers to be ready for July 10th, we have a lot of steps we need to take in advance of that, which include site investigation, wetland delineation, testing, design, engineering, cost estimating. We do internal quality control, so we'll do an internal quality control check of our documents. The guidelines that we need to meet are about 50 pages of data. It's a lot easier than doing some of our government work, but it's still, we need to go through that process and make sure that we've met all the necessary steps and included all the necessary information. We've had to meet with all the educators again and go through the description of how they're going to use all their spaces. We need to document that in meeting minutes, get it confirmed back with the educators. That all needs to be part of it. We have a community outreach where we're making sure that the community is aware of the process. We just held an eco-charrette on Earth Day, which is part of the process to understand what are the sustainability goals. We need to define those as part of our process. make sure that we have any costs associated with those. And it all culminates with both the design, the engineering, the specifications, but the cost estimate. And the cost estimate is a big portion of it because it's a grant program and we're looking for funding. So our cost estimate takes about 3 weeks by 2 professional independent cost estimators. So we need to have all of our documentation to them by May 31st so that they can take 3 weeks to do professional cost estimating. We then come back together for what we call a reconciliation meeting. It's about an 8 to 10 hour meeting where we go through line by line every dollar on the cost estimate to validate it, make sure assumptions are correct. Because the way the MSBA process works, the entire project budget is awarded at SD. And we have 14 months of design left. So there's a lot of assumptions that need to be made, and we need to make sure that the assumptions made by cost estimators are the same as the assumptions our engineers and architects are making. So it's a lot of detail.
What's an industrial hygienist?
An industrial hygienist, for our purposes of a project, is somebody who takes samples for hazardous materials and sends them off to a lab for analyzing, and then refers back to us what the material content is and how we need to categorize it for the purposes of how we would dispose of it and the costs associated with how it's disposed. So if it's asbestos, it has to be remediated and that has to be disposed of legally, and that is a very different cost to just general demolition waste or recycling.
And has there been a preliminary inspection of the buildings at 554 Lexington Street that produced evidence of Chapter 21E type substances within those buildings?
Yes, we did. Our industrial hygienist did visual inspections and site walk through all the properties back in December of 2018 and has determined we have about $2 million worth of, from visual inspection and from experience, $2 million worth of asbestos and contaminated materials that need to be removed. But we need to test those to validate it and to make sure that there's nothing that was missed.
And in order to meet this May 31st deadline that you have to get to the cost estimators, do these industrial hygienists need to be able to get into all of the buildings without any delay?
Absolutely. We are scheduled to go in this week. We need to be unencumbered so that they can go into any room, every room. It's not always about asbestos. If there's oil, if there's ballasts with mercury in them, the list of what is now hazardous materials has grown a lot in the last few years. So while it might not be contaminated, we need to also understand how much old fluorescent light bulbs they need to be disposed of properly. Thermostats that have mercury. So they need unencumbered access to every single space.
And then they take samples and send them off for testing?
Correct.
Is there any chance that they might need to get back in on immediate or short notice in order to retest or test the extent of any hazardous substances?
Yes, sometimes the initial test we'll do is a TLM test, and depending on the percentage, if it came back a very low percentage of asbestos, we would go back and do another test to have a higher level examination, because the last thing we want is to assume something is below it and then it comes in above. So we'll often go back for a second round of testing and do a different type of test to really confirm, is that less than 1% or is it over 1%?
And it may be me, and I apologize to the court as well as you. Did you mention lead paint as one of the potential substances when you were listing all those?
I did not, but lead paint is one of those potentials that needs to be removed.
And given the age of these buildings, what's the likelihood of asbestos and lead paint in the buildings?
There is a very high likelihood, even from visual inspection, there's a very high likelihood.
And I think you said, can you describe, just as briefly but as concisely as you can, how that changes, the existence of those substances, how that changes how you have to plan and bid on demolition of those buildings?
Sure, so once we've determined any hazardous materials, whether it be asbestos all the way to lead, prescriptive specifications need to be written. When we bid the project, we need to alert the bidders that there are contaminated materials that need to be disposed of legally. They need to have plans in place and demonstrate it. We need to have an industrial hygienist on site during its removal to confirm it's being removed properly. And then we have to go through the process of manifests afterwards to confirm it was disposed of legally. So from our point of view, we need to document it so that there's no ambiguity in the bidding documents. This is public bidding, whether we go 149 or 149A. It needs to be biddable and quantifiable. And it is not up to the bidders to go in and test. It is up to the designers and the engineers to be able to produce that documentation for them to rely on.
And just going back a minute, in your prior experience with any of these other high schools you mentioned, has there ever been a time when you were working on the design, construction, and the whole process of producing a new high school, where you did not have keys or a master key to get into the buildings anytime you wanted?
Not on any of the schools I've ever worked on.
So this Waltham situation is the very first time that you have, despite the request, not been given keys for access.
That is correct.
And may I approach the witness with the
Yes,
trial,
please,
just
yeah.
it may help?
And has your opposing counsel seen it?
Yeah.
I have not.
It's just a, it's the rendering of how the new high school is going to change.
No objection.
Okay, thank you.
Could you explain to the court, I think I know what it is, but I know you're going to explain it a lot better, but could you explain to the court what this chart shows?
Sure. This is an aerial map of the 46-acre property at 554 Lexington Street with an overlay of the footprint of the new building and the roadway system around the new building and the field with the parking below. It's somewhat transparent because we're trying to identify the buildings, the retreat center that it's over, St. Joseph's Hall, Bertoni Hall, the Provincial, and the garage. We're trying to demonstrate where on the site in relation this building would be. For a scale point of view, it's a large building, the new high school. The footprint is 4.5 acres, so it's quite a large area. Thank you.
And again, I apologize if I missed some of the dates, but please tell me if I'm wrong. I think you said you need to have all of the raw data collected, tested, and analyzed, which is starting this week.
Correct.
And and you have to get that takes a process. It takes time to do that, correct?
For the hazmat, we're starting this week. We've started others earlier, but yes, it takes a process.
And are those people who are on staff at SMMA, or are they independent contractors?
They're sub-consultants to us.
How long does it take you to line up a subcontractor such as these industrial hygienists and the licensed site professionals to go in and do the phase 2 testing?
I think we're all in a time when labor is a shortage, but typically it takes us 6 weeks for drillers, and it takes us 4 to 5 weeks for industrial hygienists. It's a very busy time, especially during this coming into the spring when the snow is off the ground. And
So what happens if you have, they're scheduled to come in on a particular day, and they can't get into a building for any reason? What do they do then?
they would go to a different project
And when do you get them back after they go to that different project?
when they're finished that other project.
Which could be,
It could be a couple of weeks later, it could be the following week. I mean, as it happened for ourselves, it happened to us this week. We had them scheduled to come in on Tuesday, and the weather delay postponed them finishing an earlier job, so we got pushed to Thursday. They tried to push us for 3 or 4 weeks, and I just said we can't lose that time. So we were able to negotiate Thursday and Friday instead, and they may have to work Saturday for us.
and correct me if I'm wrong, I think you said that if you don't have your full set of required submittals into the MSBA by July 1,
We need to tell the MSBA by July 1st, actually June 26th, I believe is the official date, what the cost of the project is. Our full submittal is July 10th. but there's a preemptive submittal, it's called Appendix 4C, that needs to be submitted to the MSBA 10 days before our SD submittal that outlines the cost of the project and that we're still within budget.
And right now, what is the estimated cost of the project? And I understand it's just an estimate.
Project cost is $381 million.
And what would be the estimated MSBA grant for that project cost?
Currently, it's estimated at about $126 million.
What happens to those two MSBA filing deadlines that you mentioned, July 1 and July 10th? If there is any delay at all in whatever happens, whatever your subcontractors need to do for materials testing?
If we don't submit on July 10th, we are pushed to the next submittal date, which is September. And that will put us out of sync with our extension agreement for October 31st.
What does that mean in reality in terms of this project and approval for MSBA funding?
Based on the extension letter we received from the MSBA on August 29th, if we don't meet the date for the August 28th board meeting, they may ask the city to withdraw its entire submission and go back into the process of submitting every year in the hope of being selected.
And just, I just heard you say the hope of being selected. Are cities and towns guaranteed to being selected once they've lost their position in the MSBA queue?
Absolutely not. Last year, there were 138 submissions for a core program and 12 projects were selected. And you have to resubmit every year. There is no list, there is no pipeline. You don't just fall down to the next number. You have to start over again.
But right now, in the current filing, we've passed all of the hurdles that you're talking about that we might have to go through if we don't meet the current deadlines.
Correct.
Do you have factored in, based on your experience with not only this project, but the others that SMMA is working on and yourself, is there a cost, even if you can do it in a percentage way, of any kinds of delays, construction costs, delay that's, strike that please. Based on your experience currently in the projects that you are working on, is there an acknowledged cost for annual increases over time or with delays?
Objection, Your Honor.
The form of it.
To the form of it, I don't think her expertise, as she's testified to it, would get her there, and I would also object to the relevance of it anyway for why we're here.
I think it relates to the reasonable access issue, and so I'm taking it as relevant to that. Why don't you ask a non-compound question and just lay a foundation very quickly if you
Thank
could
you.
in a question or two.
Thank you, I apologize. Based on your experience and your overseeing of many construction projects, including these school construction projects, do you see cost increases in materials and labor?
Yes.
And currently, what do those increases project at on an annual basis? And then you can do it on a percentage basis if that's what you've concluded.
So even the cost estimate for the high school has to anticipate what we call escalation. So we're putting a budget together at schematic design, but we're not going to start construction on the high school itself, the building proper, till 2021. So we have to escalate what construction materials and labor are going to cost at that time. We do that on every project we have that experience. We need to account for that. We need to account for the market. Currently, we're carrying 5.5% per annum. Labor market materials are very high. With the tariffs, costs have gone up. Steel prices have gone up, aluminum have gone up. So we're trying to factor all of that in. So it is part of our duty, as part of our cost estimate, is to include escalation for materials and labor. And right now it's 5.5% per annum.
So if you don't meet the deadlines for the current MSBA requirements as issued to you so far, and we lose out of their current budget, how does that, even assuming we can reapply and start the process over again, well, how would that affect the total cost of the project?
I just want to think about that for a second because I wouldn't know when we would get back into the program. So it would be hard to speculate, but costs have not gone down. We're all hoping costs will go down, but they have not. I don't know when we'd get awarded back into the project.
I know you go to the site often. Were you there recently?
I was there Monday.
And we had to make arrangements to get into the house, correct?
Correct, we went into Bertoni Hall.
And how long a time did that take?
For Monday's access, it was, I think, a couple of days.
And while we were there, did you try to get in touch with the person who gave you access to ask about access to one of the other buildings?
I did.
What happened?
Oh, I did not have her phone number with me. I emailed her and we didn't make connection back and forth until later. I had to go on to another meeting.
So you weren't able to get into that building that day?
Oh, no, we got into
No,
her.
excuse me, I mean, not the primary building that had already been opened up, but the building we were trying to get unlocked, correct?
Yes, so originally we were going into Bertoni Hall. The request was made to get into Provincial, but I didn't realize that. We tried to get access and I wasn't able to make connection.
And may I approach the witness?
Yes, you may. Just tell your opposing counsel what you have.
Yeah.
I have a copy, thank you.
Thank you.
Can you tell me if you've seen that before?
Yes, I have.
And I apologize, Your Honor, that is not in the list.
Thank you.
And where did you see that?
This is posted all over. It's posted at every bathroom and every sink in the building we were in.
And can you, based on the times you've been, the inspections that have been done up at the site, is there more than one building there that's winterized?
Yes, there are two buildings that have been winterized. St. Anne's and Bertoni Hall.
When you say winterized, can you explain to the court what that means?
Sure. There's no heat in the building, so they've drained the plumbing down. Electricity is still on, so you have lights to go around, but there's, for protection from frost, they've drained all the water out of the building. Shut the water off to the building.
And with regard to, there are 5 buildings other than Chapel Hall, which is a chapel, that are on the site, correct?
Correct.
And so Bertoni Hall, also known as Clark House, and St. Anne's Hall have been totally winterized and unoccupied.
That is correct.
And are you familiar with what's called St. Joseph's Hall?
I am.
That's
That's the residence.
and is that just a large single housekeeping unit kind of residence?
It's one building. It has rooms in it, sleeping rooms, living room.
And during the inspection by SMMA, how many priests appear to have been living there in 2018?
Objection, Your Honor.
I'll allow it if you give it specifically as to a month. I'd like to hear a month and date
I'm sorry.
because I think that may be in dispute. Is that part of your objection?
Actually, no, but it was more of it calls for speculation based on what you observe. What would you estimate the number of priests to be living there? She has no basis to make that answer.
I'll let her testify as to her observations and you can certainly cross-examine on
Thank
that.
you.
Okay.
So my colleague, Matt Rice, from our office, was the individual who walked through. We were preparing documentations for our project notification form filing for Mass Historic. Matt observed and actually spoke to 2 priests in St. Joseph's Hall and at the time during the walkthrough. That was December 3rd, 2018.
And when you went to Bertoni Hall this past Monday, who else was with you?
Waltham Historic Commission were with us, the superintendent of schools, Brian Black, our designer, and that was it.
I have no further questions.
Thank you, Your Honor. Do you go by Ms. Finnegan? Is that okay?
That's perfectly fine by me.
All right. Ms. Finnegan, you have declared in your direct here that you are the architect for, you are an architect as part of SMMA, and in Waltham, you're the project manager?
That is correct.
Now, you testified that the last meeting with the MSBA was in February, is that correct?
The board meeting was in February, correct?
Okay, were you present?
I was.
So you're the project manager and you were present.
I was.
Are you aware there were a whole host of people there that day, weren't there?
Board meeting is always very busy.
It is, and it's videotaped, isn't it?
It is generally not videotaped.
Well, this one was videotaped. Did you know that?
Mr. Wangler was at the boardroom that day.
Right, that's what that man over there. He was
Yes.
videotaping it for cable television, correct?
Correct?
And you were there.
That's correct.
Okay. And you're aware that the mayor was on conference call as part of that proceeding?
Correct.
Now, in that meeting, but let me come back to that meeting. You indicated you've worked on a number of school projects, and was one of them, have you worked in the city of Woburn at all?
I have not.
You've never done anything with SMA in Woburn?
I have not.
Okay, has your company?
For schools,
Yeah.
to the best of my knowledge, no.
Okay, how about in the city of Lowell?
No.
City of Lynn?
Yes.
So you've done, and what was the most recent assignment you had in the city of Lynn?
I personally have never worked on it, but I think 20 years ago we did Lynn Classical High School.
Okay, so you
Over
had
20
nothing to
years.
do with the most recent one on Brookline Ave in Lynn?
No, I did not.
Okay. Now, are you familiar with the Lowell High School building school project that's underway now?
I am familiar with it.
And are you aware that the Lowell's school building project that's underway now is to rehab the existing high school, is it not?
I'm not involved in the details of it. It's not an SMMA project. I'm
Okay.
just aware that they have a project through the MSBA.
And did you know that that was the projected highest budgeted school project in the history of the state?
Objection, Your Honor.
Are you aware?
I'll give you that question, but in terms of where the line of questioning is going, we are going to keep it just strictly confined to the matters I mentioned earlier. But you can have this question.
Okay, Your Honor, she's been talking about funding, and she's been talking about a lot of issues. I just want to be clear. Are you aware that that was the highest budgeted project in the Commonwealth?
At which point?
A year ago.
It may have been a year ago.
And guess what the highest budgeted project in the history of the Commonwealth is?
Objection.
Right,
You know-
I'm gonna sustain this objection. We're not gonna go there with these kind of questions.
You have stated already that the projected cost for this project is how much?
381 million.
Do you know of any other project in the Commonwealth that has a higher projected
Objection, Your Honor.
budget than that?
Yep, sustained.
Now, at this meeting, Ms. Finnegan, when you were present at the meeting, you listened to all of the people commenting, particularly the MSBA board members, did you not?
I did.
And at any time, did you hear any of those individuals voicing concerns about the budget concerning this project?
I did.
Objection, Your Honor.
Sustained, right? We're not going to go into the policy decisions when we hear about enforcement of the order for the matters I outlined before. We're not going to go back into the policy decisions which are left to other bodies.
Now, not policy. With respect to that hearing at the MSBA in February, did board members express concerns about litigation matters and relocation matters not being taken care of?
Objection, Your Honor.
Right, why don't I see counsel at sidebar?
Ms. Finnegan, just the February meeting was February 2019, just a few months ago, correct?
February 13th, correct.
And then you've indicated that there are subsequent meetings with the actual next meeting coming in June, the end of June, or you're meeting with them on May 31st?
We're not meeting with them in June or May 31st. We're submitting our cost estimating package to our professional cost estimators May 31st.
All right. And are you meeting as part of, you meet as part of a committee with outside committees at the MSBA?
I'm part of the designer roundtable committees of the MSBA.
Okay, and you'll make the submissions to the MSBA sometime in late May, early June.
That's not correct.
All right, late June, and then, is it June 26th and then July 6th?
June 26th, we need to submit Appendix 4C, which is the cost estimate
Okay.
update, and July 10th, we need to submit our schematic design submission.
And that's for the site investigation, correct?
No, that's for schematic design.
Schematic design, July 10th. And then on August 28th, that meeting is for what purpose?
That is the MSBA board meeting to approve the schematic design submittal.
Okay. And the study deadline for your feasibility is now October 31st, 2019, is that accurate?
The agreement, the feasibility study agreement deadline is October 31st, 2019.
As of now?
As of ever, because they're not, yes. I'm sorry,
So
I'm confused with the way you're saying.
That's a final date. In other words, there's no other activity planned after that date, is that correct?
There needs to be a new agreement in place before the end of that date.
Okay. And what is the date that you have to assess the total cost for this project? That you have to submit. What is the date that you have to submit to the MSBA, the total cost of this project?
June 26th.
All right. So June 26th is the key date. Now, turning your attention to the inspections that have been going on at the property. You're fully aware that there is a relocation expert that's been hired by the city that's been inspecting those buildings. You're aware of that, are you not?
Objection, Your Honor.
I'm going to allow it.
It has nothing to do with my process, so
No, I'm asking you, Ms. Finnegan, I'm asking you if you're aware that Mr. McParlin has been inspecting those buildings for the purposes of a relocation program.
the only way I'm aware of that is I was shared the exhibits that were sent for this case and I read them.
So the answer is you are aware that Mr. McParlin is going to that property from time to time, correct?
Objection, Your Honor.
Yeah, you can move on.
After Judge Liu's decision, which was on, I believe, September 6, 2018, that's when he ruled that there had to be reasonable access to the property. When is the first time that you inspected the property after September 6, you or anyone associated with SMNA?
Our team took some site walks in late September. We didn't have consultants start on that property until August.
Okay, and how did you garner or gain access to the property at that time?
Objection. Which, we're talking August or, I don't know.
If you could just clarify the date, but I'll let you have that question.
How did you get onto the property with your first inspection?
I guess I'm sorry I'm not understanding.
How did
the
you
question.
obtain access permission to go on the property?
I requested access through the city law department to go up to the property. I drove up to the property, parked in the parking lot, and walked around.
Okay. So you were free to go on the property on anywhere of the 46 acres, right?
Correct.
Okay. And how many times after that did you physically inspect the property as part of your project management?
Probably have been on the site about a dozen times after that.
And on all of those occasions, did you seek access through the city law department?
I notified or would meet with the building committee. We did a building committee walk, so we notified we were coming for the building committee.
And then you have all the documentations that was passed along by Mr. Savone to my office, and you were able to do your inspections, were you not?
I'm not sure I have all the documentation that was passed along, but we were told we were free to go up there.
Okay. Now, and that continued on, and on your direct examination here with Mr. Savone, you were asked about that, so you were free to go on the property, but now you, as it advances into 2019, you now need to get inside the buildings, correct?
Correct.
And the same process of letting Mr. Savone know that you wanted to get on the buildings and him forwarding that to me and you getting on the property, that continued, did it not?
That is continuing.
Okay. And I have in my hands here some of the documentation, and this is Exhibit 25th, which is a marked exhibit. And you've already testified that you've had no problems getting into the exterior, the interior, and we have the email communications that actually involve you and your company as of yesterday. As of yesterday, just before this court hearing, you requested your company to go to the property. Is that correct?
That's the only way we can get into the property.
That's correct. And what time did you request to go to the property?
I don't know what time I wrote the email. You have it in front of you.
Was it 3:45?
I send a lot of emails during the day. I don't know what time I sent it.
Why don't you tell the court who the persons you've been dealing with directly at the site when you arrive, other than my office? Is it Jessica and Joe DeSia?
Emailing Jessica and Joe Desir, correct.
Joe DeSia. And Joe DeSia, as you know, is the person that is the manager of St. Joe's Hall, where the resident priests are located. You're aware of that, right?
I am.
Okay. And you're aware that Jessica, at the other central building, which is the retreat center, right? That's where her office is, right?
I wasn't aware her office is there.
You've never been in the retreat center there with Jessica?
I've been in the center. I haven't been in her office.
All right, her office is on the first on the left. You've never been in it?
No.
Were you in it with her?
No.
Who were you in it with at that time?
They unlocked the door. I went in with Matt Rice from our office, and then I left them to it.
And you were free to go around the building?
No, I didn't stay for the building tour.
Oh, but others did?
Yes.
And they just let you in and walk around?
I don't know. I wasn't there for the building tour.
You just said you left, they stayed, and they toured the building.
I left, so I wasn't present for the building tour. I don't know if they were free to walk around.
Oh,
or if
did
they
you
walked.
hear that they were in any way blocked?
No, they were not blocked.
Now, I noticed that I'm just watching the clock here, that you were on direct for 50 minutes. And we're talking about here, reasonable access to the building. Now, you've said you know who Joe DeSir is, and he is responsible for the health care and maintenance of St. Joe's Hall. You're aware of that, right?
I'm aware of who Joe DeSir is. I do
Okay.
not know all his roles, all his duties.
All right, do you know that he takes care of all the elderly priests in that building?
Objection, Your Honor. I think it's been asked and answered
What?
more than once.
If
all
she
right.
doesn't know, you can ask a different question.
You know, when you were testifying on direct, Ms. Finnegan, you said that St. Joe's Hall, where the elderly priests lived, consisted of one large building with a bunch of rooms.
It is one building with number of rooms, correct?
Is there anything else in there that you could describe to the court that's in there?
May I access my notes? Thank you.
May,
Well,
strike the question, may I help you? There's a chapel in that
Objection,
building.
Your Honor.
just 1 minute. You can, are you withdrawing the question?
Yes.
Okay, all right, the question is
Withdraw.
withdrawn, so
Are you
please please ask you the new question.
Are you aware that there's a chapel in the building?
Yes, I am.
And are you aware that in some of the rooms, in some of the rooms, it's actually a two-story building, correct?
Correct.
And it would be, if we called a basement a third story, it would be a third story, wouldn't it?
A basement is not called a third story.
I understand that, but if it was, that's what it would be, a three-story building, right?
Objection, Your Honor.
Sustained.
Ms. Finnegan, in your direct, you never mentioned that there was a second floor level to this property. And you never mentioned that Joe DeSere and Jessica were always showing you, letting you people in to see the buildings when you wanted to. You didn't say anything like that in your direct, did you?
Objection, Your Honor.
Overruled. You can answer.
I said it was a building, I didn't say how many stories.
But you were quick to offer an opinion about how many priests might be wandering around that building at any time. You were asked that question, weren't you?
Sustained. Sustained.
Do you know they have masses in there and confessions and functions in that building? St. Joe's? Did you know that?
Was not aware.
Did you know that anytime when you were walking around there, you could have been looking at people that are, to use the term, I know it's stigmatine, but they are participants in the stigmatine parish, we'll call it, even though it isn't a parish. But the people wandering around that building at any time could be people just attending stigmatine events, right?
Imagine so.
Okay, so when you were talking about how many priests were walking around there, you were sort of speculating, weren't you?
No, what I said was that my colleague Matt Rice spoke to 2 priests.
Oh, so Matt Rice talked to a couple of priests in this 3-story building, right? And that's where you got your information. Is that right?
That's
Yes or
correct.
no?
Yes, I said.
Okay. Now, let's go to another thing. When you said that this building had a number of rooms that, do you know some of the rooms have sinks in them and other facilities in the rooms?
Correct, small kitchenette, etc.
What's that?
Small kitchenette.
A small kitchenette.
Yep.
You didn't mention that on your direct with Mr. Savone, did you?
No.
And some rooms are larger than others, aren't they?
It's a building of many different rooms. I'm not sure I
Oh.
went into the details of
Okay.
the layout of the building, the size of the building, the stories, or what it is.
And as you enter that building on the first level, you walk in there, if you take a right, first of all, there's a lavatory right there, correct? When you first come in the front door? You don't know. Did you know that in St. Joe's, which Joe DeSere has to supervise, on the right, there is a massive living room with a number of TVs located there with sofas and chairs?
Objection, Your Honor.
Sustained.
All right. That's true. On your direct, did you mention anything about this property having a full basement with a full, entire length of the building, a cafeteria and dining room with an elevator servicing the elderly priests?
Objection, Your Honor.
Overruled. You can have this one.
I did not mention anything about that.
Were you aware that that existed?
I don't recall the elevator, but there is spaces.
You
in
don't
the
recall the
basement.
elevator?
There's
Objection, Your Honor. And she keeps
Yes, let her-
interrupting the witness.
Yes. Let's let someone finish speaking.
Yes, it contains a full kitchen in the basement level.
Well, you know, you detail all these scientific tests your company has to do and the things that are required with radon and lead and all that stuff. You talked about that, right?
I did.
And you talked about the importance of getting in there to look around and test facilities, right?
Correct.
Test the various areas. But you didn't even know that there was an elevator plus a stairway plus a 3rd level or a 2nd floor, calling the basement a level. You didn't mention anything about that. Did you ever inspect the cafeteria?
Objection, Your Honor.
Sustained is to the form. You can
Oh.
ask her, did she ever inspect the cafeteria?
Have you ever been in the basement
We
of
wa-
St.
our,
Joe?
our team walked through the building.
Were you part of that team?
I did not walk through the basement of St. Joe's.
Ah. By the way, as the project manager, I've only asked you about really one building right so far, right? Do you realize this project calls for a demolition of every single building on that site?
I do.
So you were talking about this environmental issue, about something that you now have some paperwork telling you, and you haven't completed your study there, right?
We haven't completed all the testing and analysis, correct?
All right, but you were very quick to say we've got a $2 million environmental situation with this property, right?
I said we have an assumed $2 million from the visual inspection.
Oh, from the visual inspection. Do you have any report showing that?
Yes, that is part of the feasibility study submission.
Do you have the report with you here today?
I don't have I have the data that shows what they assumed it was in.
What they assumed it was, but now they're continuing to test, correct?
Correct.
And on every one of these buildings, they're just gonna demolish them all and take everything that's there off-site, correct?
Correct.
Or use whatever's there that's usable on the site, right?
For the buildings, we would most likely remove everything off-site.
Okay, so you just have the flattened site down below there where St. Joe's and the rest of the buildings are, correct?
Correct.
All right. Now, how many buildings are on the site?
6.
Total of 6. We did St. Joe's. Petone Hall. Who was in there yesterday when Jessica opened the door for everybody? Who was there at that time?
Kathy opened the door yesterday.
Kathy from one of the Stigmatine employees, right?
I don't know who she is. She said her name was Kathy. She
Okay.
opened the door yesterday.
All right, she had keys to the building. Kathy works there too.
Okay.
So she opened the door, right?
Yep.
And Jessica had been there earlier, right?
Jessica came after Kathy.
Right, and you're aware, aren't you? You've emailed with Jessica, haven't you?
I have.
Yeah, and you know she's got a baby at home, right?
I do.
Okay. And on that day, yesterday, Jessica got you in, Kathy opened the door, and what were you instructed? Petone Hall is one of the historic properties, potentially historic properties.
Objection, Your Honor. I don't know, are we getting testimony from?
I'm gonna ask a question.
What's
I'll ask a
historical?
question.
Just 1 minute, let's hear the question first.
Are you aware that Petone Hall might be a historic property?
Bertoni Hall is listed on the inventory registers for Mass Historic. We have filed our P&F and had a response from Mass Historic, and we've been through the process with Waltham Historic already.
Have you ever walked inside that building?
Yes, I have.
And you've seen all of the moldings, the chalices, and all the religious personal property that's located in there?
Objection.
Sustained.
Have you observed? Why don't you, when you were in Petone Hall, could you describe what you saw in terms of personal property that was there?
Objection, Your Honor.
Sustained, unless you can tell me what's relevant about this.
Do you know why Petone Hall is considered historic? Do you-
Objection.
Sustained.
When your people went in Petone Hall yesterday, they wanted to stay there some extra time, right?
Yes, they did.
Isn't it not a fact that Kathy said to your people, no problem, stay as long as you want, the door self-locks, just shut the door when you leave?
That's exactly what she said.
Now, the retreat center. Do you know what it's used for?
I know the intent of what it is used for. Preparation for marriage, pre-Cana, marriage counseling.
Retreats? Retreats?
Sure.
Functions? Outside and in, right? How many levels?
It's a 3-story building.
You're including the basement as a...
No, I'm not.
You're calling it a 3-story building?
The way the grade changes, it's technically considered a 3-story building.
All right, but there's basically 2 living areas going across. I know what you're saying, but let's get going here. It's 2 stories of living area there, right? With a basement.
There's many functions in their space. It's the
How many-
kitchen, it's got an auditorium, it has reception rooms, it has dormitory rooms, a church area.
Has an enormous church there, doesn't it?
Does,
And it's got it's got the tabernacles, the statues, all of that stuff all over the building, doesn't it?
Objection, Your Honor.
I'm asking her to describe.
And does this relate in any way to reasonable access?
Yes, it does, Your Honor.
Okay, all right, I'll let you have it.
it has a lot of stuff in it,
A
yes.
lot of personal stuff in there, right? Okay. What's in the basement of the, you mentioned an auditorium, the chapels and the things like that. How many, what's in the basement?
I don't know, I didn't go to the basement, so I don't know what they said was in the basement.
You're the project manager, though.
I am the project manager, correct.
Did you know the basement has a full dining room with a massive kitchen area? Did you know
We consider
that?
floor 1 to have the kitchen area, but
What's that? I'm
we
sorry.
consider floor 1 to have the kitchen area,
Right.
the way it's defined.
I'm trying to be helpful here. There is a basement level?
There is a basement level.
All right. There's a auditorium and there's a basement that has a dining area, correct?
Like I said, I wasn't in the basement.
So you're unaware of that?
I'm not sure what it has anything to do with.
Well, you wanted access to the buildings, right? You're getting access as the project manager. Ms. Finnegan, you've been asking for access.
Objection, Your
Just one
Honor.
minute, just 1 minute, please. Let's get an answer to that question.
I'm the manager of a design team, and I got access for our team into the buildings. Our teams have been in the buildings. Whether I personally have been in every square footage of the building is not relevant from my role as the project manager.
Oh, okay. But you were describing these buildings on direct testimony, right?
I was not going into detail on every single
Oh,
square
you
foot.
certainly were.
Objection.
But I am. Now, you are now aware.
Just 1 minute, just 1 minute. You need to let me have time to make the ruling, you need to wait. That one was sustained, right?
Have your people told you, the consultants you work with, that there's a full dining area and kitchen facility in the basement level?
They have documented what's in the buildings.
And is that part of their documentation?
May I refer to it?
Sure.
They reference the kitchen and dining. They don't go into the level of detail that you're looking for, I think. They're listing out the spaces as part of their documentation. They're defining what potential visual hazmat materials they find. It's not necessary for them to say what functions are occurring in every space.
So there's no notation there that there's a kitchen and dining facility?
There is notation that there is a kitchen.
There is,
Yes.
on the basement level.
It does not say basement level in the notation.
Okay.
It's not relevant for what I need it for.
To clear this up, Your Honor, you know that there's a short stair situation in the retreat center.
Yes.
That explains the elevations, right? You know that the cafeteria and the kitchen area is located below, right?
Correct.
All right. And then if you come up, now you're dealing with all of the rooms, correct? How many rooms?
I do not know how many rooms.
Okay. And you didn't think that was important to know how many rooms were in the retreat center for your testimony here today?
No, I did not.
Did you think it was important that you try to get information about counting priests from one of your employees?
We didn't count priests.
Now, Ms. Finnegan, would you agree with me that you have been accommodated without restriction every single time since September 6th of 2018?
Objection.
Overruled.
To the best of my knowledge, I've been able to gain access when I've asked through the city.
Now, you testified a lot about the MSBA deadlines. You gave the dates and you're all in sync. And I ask you this question. Do you believe that this school project, okay, is more important than the constitutional rights of my client?
Objection.
Sustained.
What do you know about relocation as a project manager? Do you know anything about it?
Objection, Your Honor.
Overruled. I'm going to let her answer this based on what she knows about it.
I know very little. I've read the exhibits that were submitted as part of this case.
You know relocation is a requirement in an eminent domain case, right?
Objection, Your Honor.
That's sustained.
The emails about access and everything, you've seen copies of all these, right?
If they were the ones I've sent, I have.
Okay, the back and forth, you've seen them all?
Objection, Your Honor.
Well, are these agreed upon exhibits?
Yes.
They're before me, any of them?
Yes. All right. Just let me check.
Sure.
Ms. Finnegan, final question. You're the project manager, your company's doing the project, right?
Correct.
Have you got information from the MSBA? Have they supplied you information that they have considerable concerns with the city making deadlines and controlling costs?
Objection.
Overruled. I'll let you have this one.
May I ask for a clarification?
No. The question's before you. Have you been supplied information?
Supplied information, that's where I.
Any source of information
We have
from the
letters-
MSBA or from the city?
MSBA sends.
I have to.
Your Honor,
object to the
she's trying to
process.
backtrack and use her attorney who she keeps looking at and looking
Just one
over at
moment,
you.
Just one moment, okay. Let's have one clear, concise question, and then you can answer it as best you can, and I'm gonna ask you not to interrupt the witness or interrupt me.
Yes, Your Honor, of course. Would you answer the question?
I have letters from the MSBA that have been issued on behalf of the project regarding access, ownership, and control of the site and the cost of the project.
Okay. I have no further questions.
Thank you. Anything further?
Yeah, sure. Attorney Flynn was talking about different periods of time and asking about problems with access. Back in August of 2018, did you have any problems with access to the site when you needed some of the subcontractors who are doing exterior work on the site actually be able to get on the site?
Yes, we were physically blocked from entering the site.
And how did that affect the scheduling of their work, and then in turn, whatever domino effect it had on yours?
So we had our topographical surveyor who was blocked. They had been booked for 6 weeks in advance. They were stopped for 5 days in a row, and we lost them for 4 weeks.
And I want to focus your attention on the questions that were about the ultimate permission to gain access to the buildings or the exterior. How long does the process, as opposed to when you ultimately get permission, how many days does it take for this process to work, to get permission to enter a building or get on the site?
In general, we've given ourselves about 3 to 4 days from when I first send the request through your office, because it takes time for everybody to get back and forth.
Thank you. No further questions.
I have a couple.
Yes,
Ronnie,
you may.
open the door. Ms. Finnegan, Mr. Sabone just asked you about August of 2018, right?
Correct?
Now, you know Judge Liu's hearing was September 6th of 2018. So you were blocked prior to that hearing in his rulings, right?
Correct.
Okay. And were you aware, you must be aware if you've read everything, you were aware that the city sued the Stigmatines?
I am aware of that.
Okay. So we ended up in court on September 6th, and whatever was going on prior to September 6th was between the city and the Stigmatines, right?
Objection.
Sustained.
The final thing, you were blocked in August of 2018, right?
Correct.
Did you know their relocation expert, Mr. McPowan, wasn't approved or authorized as an advisory relocation expert until August
Objection.
30th? Let me finish this question. Until August 30th, 2018?
Objection.
Overruled.
I know nothing about the relocation.
I have no further questions.
Okay. All right, thank you. You may step down. All right, well, let's see council at sidebar about scheduling, and we will probably take our brief morning recess, but let me just talk to council, and then I'll come back and tell everyone what the plan is for scheduling.
Thank you, may be seated, court is now in session.
If I may, Ron, I think just to try to save time.
Your Honor, we're back on the record in case in hearing.
Thank you. Yes.
In order to try to save time on some of the background qualifications, we've agreed that this, and I apologize, it's my own copy, is a CV of Drew Echelson, who will be the next witness.
Okay, thank you. And is there any objection to that?
There's no objection, Your Honor, but to the resume.
Yes.
My objection to him being called, as I understand it, he's going to reinforce a couple of things about the emergency timeline situation that the MSBA dictates. I can't imagine we haven't beat that enough.
Well, it's potentially relevant to the issue of reasonable access.
I understand.
So I'm not going to
I
prevent the
understand.
parties from putting in evidence on either side of that issue.
Understood.
All right.
Would you like this marked as an ID?
Yes, please.
It'll be marked as ID A.
If I may, additional housekeeping matter, you were asking about before,
Yes.
while we were at sidebar, the two letters from the mayor.
Okay.
The letter of 9/12/18
Okay.
is part of Exhibit 26.
Thank
you.
as an attachment to the city's admissions. They reference the letter and attach it. And the second letter is marked separately, it's one page. That's Exhibit 19. That letter is 2817.
2817. And I'm sorry, give me the exhibit one more time, please.
Exhibit 19.
Thank you very much. Okay, great. All right, and then I also have the letter today that's dated May 1st, 2019, from the City Law Department. And that does clarify, crystallize the issue of the notice to vacate and/or date of displacement for me. So it really does make sense at this point to focus on reasonable access during the interim time. Okay, thank you.
I would call Drew Echelson for the stand.
Come right up here, please. You can raise your right hand, face the clerk, please.
Do you solemnly swear the testimony you should give the court in the case now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please be
Right up
seated.
there. You can adjust the mic any way you need to, and just ask to keep your voice up.
Thank you.
The
Thank
resume?
you.
Thank you very much.
Sir, could you state your name for the record and spell your last name?
Yes, my name is Drew Echelson, Echelson.
Thank you very much.
I'd like to approach the witness and show you a document that's been marked as A, ICA.
Yes,
Can you identify that, please?
it is my resume.
Thank you. And during the time period that you heard Architect Finnegan testify about all these meetings to the, with the MSBA and the whole application process, you also heard her talk about the deadlines.
Yes.
And can you tell us why the issue of accreditation is tied inextricably to those deadlines?
Yes. In 2010, before I started as superintendent, Waltham went through an accreditation process with an organization called NIASC. They're the organization that accredits high schools. And during that time, and during that process, their analysis led them to believe that if there weren't substantial improvements to the high school at Waltham High School, that we would not be able to move forward with accreditation. When I started as superintendent in 2015, the district was again through the re-accreditation process with the organization NIASC. And at that point, they were pleasantly surprised by the progress we had made relative to the MSBA project, and communicated in that report that if we did not continue on the path toward this progress, that when they come back out in 2020 or 2021 and had not made significant progress, that we would be at risk of losing accreditation in the city of Waltham. This would of course have a devastating impact on so many students who depend on that accreditation in terms of their process for applying to colleges and other career and community opportunities.
And if this particular project, as it's been going through MSBA, does not make the acceptance through, I think, the deadline of October 2019, what happens then with that accreditation?
Yeah, my understanding from reading the MSBA communication and our in-person meetings with the MSBA staff, that if we do not make this deadline, Waltham will be asked and encouraged to resubmit an SOI. Waltham previously submitted, I believe, 4 SOI applications before we were eventually admitted into the MSBA process. So this too would have a very devastating impact, I think, on an entire community. When I started as superintendent, there were roughly 5,400 students in the city of Waltham. That number is up to 5,700 just 3.5 years later. It is a growing city, it is a diverse community. This community is depending on a new high school and ensuring that we have an accredited high school.
I have no further questions.
Cross-exam.
No question, John.
Thank you very much. Please step down. Mr. Stone, any further live witnesses?
No, Your Honor.
Okay, all right. And in terms of findings that you would like me to make in terms of how many priests reside at any given time, could you tell me the city's position? I'm going to ask the defendant for the same thing, as to what is the relevant date that that finding needs to be made as of. In other words, is it the city council vote in June 2018? Is it the date of the taking and recording on July 23rd, 2018?
You are right on the point, Your Honor. Under Chapter 79, the effective date is the recording date, which is 7/23/18.
All right.
That's Exhibit 2, I believe.
Exhibit 2. And what is your view of what's in the evidence to determine the number of priests residing there as of that date, the date of the recording?
Well, one of our admissions, and I think it's somewhere between admission numbers 14 and 17, and there's an attachment to it, say that between June and July of 2018, there were 3 to 4 priests residing in St. Joseph's Hall.
Yes. Okay. All right. And let me ask the same question to the defendants. What is your position
No,
on
I
that?
don't believe the statute speaks to that determination being made on a date certain. And that admission has been the subject of a supplemental admission. You're going to hear more testimony about that today.
Okay.
That admission was very specific. How many were regularly there that month? And the answer was 3 to 4.
Okay.
If asked on the stand, and there's documentation from the Stigmatine Fathers' regular business records, I have it there, a graph that lists all their priests, dates of birth, when they joined, where they live, where they're domiciled, what their community assignment is. And not so coincidentally, it's dated the week of the taking. It's a monthly thing, so the one for the end of July 2018 lists at least 9 of them. When the question is, how many considered it home at the time of the taking? The answer is 9 or 10, not 3 or 4. That was not the question posed in the admission that the city relies upon so heavily.
Okay. And what is your view of when the priests move in? In other words, was the June date of having 3 or 4 correct and then additional priests move in, or was that one June date just always wrong?
No, as you'll hear from Father White, who takes the stand, it's not wrong. He was asked to recall how many were regularly there. And what he'll explain is, at any given time, and we have documents from the mayor herself, 8 or 10 are registered through census, registered vote there. They stay there, they're domiciled there. They have been from 2017 right up until today. The 3 or 4 says how many were there regularly that month. He estimates 3 or 4 because someone might go to a different parish for a week. Someone might go to a different parish for a month. Another might go on a retreat. At the time, 2 of them were in nursing homes. But you'll never... The city has turned that 3 or 4 priests into something it isn't and never was, Your Honor.
That's fine. I just want to make sure you have a chance to put in all the evidence you want.
Thank
you. Okay. All right. And so nothing further from the plaintiff, is that right?
Correct, Your Honor.
Okay. Thank you. Let's go to defense.
Defense calls Stephen Mollica.
Just raise your right hand and face the clerk, please.
Do you solemnly swear the testimony you should give the court in the case now in hearing should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be
Just
seated.
You can just have a seat, adjust the mic any way you need to. I just ask you to keep your voice up. Thank you.
And could you state your name for the record and spell your last name, please?
Yes, Stephen Mollica, Mollica.
Thank you.
Thank you, Mr. Mollica. Forgive me if I speak fast. I know you have an engagement tomorrow. We're going to try to get your testimony done today. Tell us where you live and what you do for work, please.
I live in Hudson, Massachusetts, and I am a relocation consultant.
And do you do that under a certain company, or are you on your own?
The name of the company is WD Shock Associates.
And how long have you worked for that company?
I've worked with them for 15 years,
And how long have you worked in the relocation field?
30 years.
And do you have any experience in that 30 years, particularly with respect to eminent domain takings?
Yes, I would say nearly all of the work I've been involved in with relocation has been a result of takings through eminent domain.
And how many relocation plans would you say you've been involved in?
Dozens between my own work and when I was at the Relocation Bureau.
And the vast majority a result from the fact that an agency took property by eminent domain and occupants got displaced.
That's correct.
And for a period of time, did you work for the State Relocation Bureau?
Yes, I was the director of the Relocation Bureau for approximately 10 years.
And when was that?
That was from 1993 until 2003.
And what types of things did you do as the director of the Relocation Bureau for Massachusetts?
I was responsible on a daily basis to provide guidance and assistance to displacing agencies, municipalities, any public agencies that were involved in possibly relocating businesses or residences. I was involved with was responsible for the approval of relocation plans, provided advice to town council, city solicitors, generally would get the word out regarding relocation obligations when there was displacement. I was involved in hearings whenever there was any grievances, and I was also responsible for drafting the current regulations as well as the guidances that are in effect.
Current regulations, that you're referring to the 760 CMR?
760 CMR 27.
You were involved with the drafting of them?
Yes.
What did you have as a basis to draft those? Was there a...
Well, at the time we were given instructions, all of the agencies, to revise the regulations. As part of that initiative, we were responsible for reviewing and doing a top-to-bottom revision of the regulations that had been in effect. The result was the current regulations. Now
Are
promulgated.
you familiar with the relocation statute in Massachusetts, which is Chapter 79A?
79A, right. Yeah.
And was that used as a basis when you participated in writing the CMRs that pertain to relocation?
79A was certainly used as the basis. The existing regulations that were in effect prior to were used. We also looked at the federal regulations, 49 CFR 24.
So not only are you familiar with the relocation regulations, you wrote them.
Well,
Participated in writing.
Yeah, there were a lot of red lines from the agency's attorney, but no.
What are some of the larger relocation projects that you've been involved in?
You know, in
Two in the past
some way
few
or another
years.
in the past few years, Green Line extension. I had done some consulting on that. I've been involved with airport acquisitions. Pretty much any project I'm trying to think, urban renewal programs, school construction projects, City of Lowell, new schools. Trying to think of.
And would it be fair to say Massachusetts law dictates that anybody displaced by an eminent domain taking by a public agency is entitled to relocation to some extent?
Yes.
And the extent to which they get relocation assistance is dictated by, among other things, the number of units involved that they're being displaced from.
The number of units involved would be only pertinent with respect to preparing a relocation plan.
Okay. And is there a number that triggers a certain plan?
Yes, 79A requires a relocation plan be prepared and filed if there's 5 or more dwelling units or business units to be displaced.
Okay. And if there's...
I should add, there's also within the regulations a small projects relocation plan filing where a displacing agency can, at their option, submit a relocation plan to the Relocation Bureau for review.
If it's less than 5 dwelling or business units that are displaced, those occupants are still entitled to some relocation assistance, correct?
Yes, if they're otherwise eligible.
And before we get into what would be the contents of the plan if you're 6 or more units displaced as opposed to less than that displaced, before we get into that, is there a process by which the number of units is determined?
Well, the process would involve the diligence of the Relocation Advisory Agency to determine how many units of businesses or residences are likely to be displaced as a result of the acquisition.
Based on your, well, let's back up, I'm sorry, strike that. Have you had the opportunity to inspect the Waltham campus of the Stigmatine Fathers?
I have. I was there on December 6th.
And based on that inspection, did you make a determination as to how many units are being displaced because of this taking?
Yeah, I mean, this isn't a typical sort of property, so it is a little bit more difficult. However, on my inspection, I saw in the St. Joseph's home to be evidence of at least 5 priests who seem to be living there. There's also the business itself of the espousal center. And I don't know whether or not you'd characterize the gift shop as a separate entity. And then I believe there was also one person living in the espousal center facility as well.
Is that some type of full-time live-in caretaker?
As it was represented to me, it was a full-time person living there as a caretaker.
So even if you don't separate the gift shop, you're more than 6
Objection.
units being displaced, right? I mean, I'm just counting what
Okay, just 1 minute.
Mm.
Yes, it's overruled, and we have this question.
you said you weren't sure as to how to characterize the gift shop. Even if you don't count that as a unit, didn't you just count more than 6 units being displaced by this taking?
Yes.
So by your understanding and your experience of Chapter 79A, those occupants being displaced on this campus are entitled to a relocation plan as defined by 79A, correct?
Objection, Your Honor, and it goes to what was the focus and also my motions in limine. I just don't want to be considered to have waived that objection, but.
I understand. I'm going to let him have this one, but your
Thank you.
objections are noted.
Well, it's more the requirement that a relocation plan be prepared by the displacing agency and submitted to the Relocation Bureau for approval. You know, the scope of the benefits wouldn't change necessarily in terms of monetary assistance or advisory services. But the triggering number for the requirement that a plan be filed would be related to that number.
And you understand that the city took this property in July of 2018, correct?
That's my understanding.
And what is your understanding of when the relocation process under the statute is to take effect based on the date of taking?
Well, there's things that need to be done prior to the taking, and then there's things that are to be done after the taking. And
What's required to be done before the taking?
before the taking, the displacing agency is required to be designated as a relocation advisory agency by the Relocation Bureau.
Do you know, I'm sorry.
I'm
go ahead.
sorry, yeah. And in the regulations, 45 days before property acquisition or project commencement, a relocation plan is required to be filed.
To your knowledge,
And then, I'm sorry,
no.
just to continue.
Yep.
The triggering event for a person to be considered eligible and displaced is either the date of initiation of negotiations, which is the written offer by the displacing agency for the property, or the date of the taking.
Thank you. Do you know who has been assigned as the relocation agent for the city?
I believe Auxilium has been, yeah.
Do you know the gentleman's name?
Yes, Michael McParland.
Do you have any knowledge of when Mr. McParland was approved by the Bureau?
I believe it was August of 2018.
A month after the taking.
I believe so.
So do you know whether he submitted a plan, or whether any relocation plan has been submitted on behalf of the city before the taking?
I don't believe a relocation plan's been submitted.
To this day, has there been one submitted?
To my knowledge, no.
And to your knowledge, I'm sorry, I think you already said this, 79A and the 760 Code of Mass Regulations pertains to any agency that takes property in Massachusetts and as a result displaces people.
That's correct.
Does it apply to urban renewal project takings?
It would.
It doesn't apply to only them, does it?
No.
I'll show you a document that's been marked, Mr. Mollica, as Exhibit 26. which is requests for admissions. May I approach, Ron?
Yes, you may.
For the responses of Mayor McCarthy to requested admissions that I sent to her council. And I draw your attention to her answer to number 14. And if you could read to the court, please, the sentence starting with around.
Okay. Around the time of the effective date of the taking.
Just the record.
Yes.
To me, if there are objections, and admission is a whole document, it's not one sentence, so I'm just,
Yes, the whole
I'm
thing's
noting
in
my,
reference, yes.
I'm noting my objection to only a portion, but I'm fine with dealing with that on cross.
Okay, all right, thank you.
Around the time of the effective date of the taking, defendant was notified orally and in writing that if it now wished to choose Chapter 79A relocation instead of remaining on site, it should contact the city's state-approved relocation consultant, Auxilium. Defendant has never done so, thus this is otherwise denied.
Thank you. My question, Mr. Mollica, have you ever heard of an agency that makes a taking by eminent domain tell the occupants that are displaced that they have to choose? You can get the relocation rights you have under Massachusetts law, or you can stay beyond the date of the taking, but you can't have both.
No.
Have you ever heard any connection between relocation rights and how long a taking agency may let the occupants stay beyond the date of taking?
No.
If your determination is right that there's at least 6 dwelling or business units, the occupants of which are being displaced here, what goes into the necessary relocation plan? Can you tell us generally the contents of the plan?
Yeah, if I can just look at my notes, there's basically 7 or 8 requirements that a relocation plan should include. A narrative description of the project, the number of business units or residents to be displaced, the date displacement is to begin. You have to describe the needs of the occupants who are to be displaced, comment and discuss the availability of decent, safe, and sanitary housing to meet the needs of the people who would be displaced, provide an estimate of cost of relocation, describe the source of funding, provide an assurance statement that benefits would be provided, coordinate with other displacement activity in the area, provide a summary of procedures and a summary of the appeal procedures that would be in place.
Has the city, to your knowledge, has the city, through Mr. McParland or anybody else, come up with those parameters for the Stigmatine fathers?
To my understanding, no.
What would go in the plan that the occupants would be entitled to if there were only 3 or 4 dwelling units determined to be displaced in this situation?
What would go into the plan?
They wouldn't be entitled to all the contents you just listed, right?
No, I mean, that's the contents of this document called a relocation plan. The purpose of the relocation plan is before property is acquired for displacing agencies to think about problems that they might run into in displacing anyone and provide some solutions as to how they're going to solve those problems. And it also provides the people who are going to be displaced with an opportunity to comment on the relocation plan that's been filed. And then that's reviewed by the Relocation Bureau. That's an independent agency that, is set up to review plans and assess whether or not the displacing agencies have properly considered problems that could happen when someone's being displaced.
Would it be fair for me to say that's the purpose of the statute?
The purpose of the
Of
statute.
79A and the
of
CMR
70
regulations about relocation?
Right. I mean,
That goes to the heart.
The general purpose is to make sure that people who are displaced don't suffer disproportionately as a result of takings.
Have you seen any documentation or any other source of information to show that the city has offered anything you just listed to the Stigmatine fathers at any point in time right up to this date?
I've seen nothing.
To your understanding, Mr. McParland hasn't even put together his final study yet, correct?
That's my understanding.
He's out there in the field working on it as far as you know.
That's what I know, yeah.
So clearly, the city The city said has hired him to do the relocation plan. They say we don't even get entitled to, right?
Yeah, it appears that way.
Now, I'm sorry, I cut you off. You were telling us the method of assistance would be, method may not be the right word, but if it's, say, 3 dwelling units are being displaced, what does the relocation program or
Well, anyone
Plan
displaced
look like?
is still eligible for the benefits that are outlined within the statute and the regulations. You know, if you're determined to be a lawful occupant and you're displaced as a result of a taking or certain other actions, then you're eligible if you are having to move from where you live or having to move your business.
And you said then typically the occupants are entitled to time to review and comment on the relocation parameters that the agency has come up with?
If a relocation plan is required to be filed within the 760 CMR, is a requirement that a notice be sent out to the affected occupants, providing them a reasonable time to comment on the relocation plan before the Relocation Bureau takes action on the relocation plan.
Have you ever heard of, in all your experience, all your projects, have you ever heard of displacement coming before any of that?
Displacement.
Displacement
No,
coming out
this-
before the plan that tells you how you're going to be displaced and where you're going to go?
No, I mean, no, there's a reason why there's a process.
And as you described it, because the occupants are going to be,
Well,
go ahead, sorry.
they're having to move as a result of a taking by a government agency, right?
As you know, the Stigmatines fathers have been there for, is it 100 years or nearly 100 years?
A long time.
In the timeline with respect to a taking and a relocation plan, the statute references the time which public approval of the taking is sought, doesn't it?
Public approval, yes.
Is that the vote of the city council in this situation?
Yeah, it would be. It's not defined in 79A, but it would be project, yes, right.
And to your understanding, was a plan in place before the city of Waltham voted to take this property back in June of 2018?
No, not to my understanding.
And that violates the express terms of the statute, correct?
The CMR requires that 45 days before project commencement or property acquisition, that a relocation plan be filed and approved by the...
And to your understanding, Mr. McParland wasn't even hired at that point, was he?
I don't believe so.
Wasn't even hired when the city then went ahead and took the property?
That's what I understand.
I think you told us he was approved by the state to do this type of work on August 30th, 2018, which was about 6 weeks after the taking.
That's right.
Does the statute provide, or any other Massachusetts law, provide a way to cure violations like that?
Not that I know.
This,
Overruled. I'll allow it.
Does the statute or any other Massachusetts law provide an example? Another clause which says something to the extent of, by the way, should this deadline be met, should there not be a plan in place, this can easily be cured in however manner.
No, not specifically. The only thing I can think of is that the designation of a relocation advisory agency could be suspended by the Relocation Bureau if they determined that the program wasn't proceeding within parameters of the requirements.
Safe to say some relocation projects are more complicated than others?
They're like snowflakes. Each one is different.
Where would you rank this one on a complication scale based on your experience?
This is very complicated, very complicated, I would say, within the top 10%. It's not a typical retail operation. You have people who are living there that are going to have to move. You have a facility that's very unique and that would be difficult in any circumstances to find suitable replacement locations. You know, I'm would be more concerned about who seems to be living in the St. Joseph's home, which is essentially a nursing home, and how to replicate something like that for replacement housing. There's requirements in these rules that about providing decent, safe, sanitary, comparable replacement housing for anyone who's displaced. I'm not really sure how they can provide something that's entirely comparable to what they have right now. Which is why in a relocation plan, you would describe all of that. You would say, geez, this is a problem it looks like we have. What are we going to do to try to mitigate that within the rules? Think about it before, not, you know.
Do you understand that the Relocation Bureau has sort of exclusive jurisdiction over certain disputes with regard to relocation, like payments?
Yeah, if you're aggrieved by determination of eligibility or for benefits, then it would become a matter to go before the Relocation Bureau appeal.
Does that have anything to do with the statutory requirement that you can't displace somebody until you give them the relocation plan consistent with the statute?
No, it doesn't.
Just 1 second. Can you repeat that? I was just writing.
Does the fact that the State Relocation Bureau has jurisdiction over certain complaints about payments have any connection to the importance of relocation in this case being you can't displace somebody until you've given them the relocation plan?
It's probably going to be a form objection. Why don't you state it a little bit more clearly?
Came out better the first time.
Could I?
Just one moment. He's going to ask you a new question.
Okay.
And I do understand that I'll be making the final determination, but I'll take the evidence and decide what credit to give it.
As far as you know, and you told us you wrote participated in writing the regulations and you remarkable experience using them. Does the Bureau of Relocation have any jurisdiction at all over making a determination that you can displace somebody before you give them their relocation plan?
Objection.
Overruled. You can answer.
Jurisdiction of the Relocation Bureau with regard to appeals is limited to a determination of eligibility for or receipt of benefits. So it is limited in that regard. Their jurisdiction would, through the appeal process that's in place, would be that if you're aggrieved by the amount of or determination, then you would go to the Relocation Bureau for that. In terms of whether or not their jurisdiction would cover an appeal regarding the requirement that a relocation plan even be filed doesn't seem to fall within that scope of eligibility for or determination of benefits.
The clause that speaks to their exclusive jurisdiction has nothing to do with the relocation plan coming after displacement. Is that, to put it another way?
Objection, Your Honor.
Is that a fair statement?
Overruled. I'll let you answer.
Yes, that's a fair statement.
Thank you. No more questions, Your Honor.
Thank you. Cross-examine.
Well, there's a problem, Your Honor. Mr. McFarland, who was subpoenaed by defendant, has just informed me, anyway, at the break, he's scheduled for a medical, an operation of some sort of medical procedure tomorrow. So I was wondering if I could do cross-examination later and let them put on Mr. McFarland so he can go to his medical procedure tomorrow.
I will say that during the course of hearings or trials, we do routinely grant requests to take people out of order when there are events like that. Is there any objection to allowing that because there's a medical issue?
There is, Your Honor. I absolutely agree that generally happens, but I've never heard of it going in the middle of testimony while there's still cross-examination to come. I defer to obviously to the court on the issue, but if he's going to be cross-examined, Raymond, this is the opportunity.
Let me see everybody at sidebar on the meeting, scheduling with different people, and thank you for being willing to come back if necessary to our current witness. All right, so we're going to suspend that.
Mr. McFarland, could you, what's going on? Are you calling your next witness, please?
Yes, Mr. Flynn, thank you.
Thank you.
You can just come right over here, please. Raise your right hand and face the court.
Do you solemnly swear the testimony you should give the court in the case now in hearing should be the truth, the whole truth, and nothing but the truth? So help you God. Please be seated.
You just adjust the mic any way you need to. I just ask you to keep your voice up, please. Thank you.
Could you please state your name for the record and spell your last name?
Michael McParland, MC, capital P-A-R-L-A-N-D.
Thank you. What's that?
May I proceed? Thank
Yes,
you.
of course.
Mr. McParland, how long have you been in the relocation business?
30 years.
And have you been qualified as a relocation advisory agent in the past?
Probably 50 times.
And you continue to do it to this day, do you not?
We work both sides of the street.
All right, so you work for landowners and you work for taking authorities?
We primarily work for businesses who are being taken
Okay.
and to make sure they don't leave any money on the table.
All right, you've had a lot of relocation experience, true?
A lot of experience.
All right. Now, with respect to the subject property, you were actually, when were you first contacted by the city?
I would say in the summer of 18.
July or August? July?
I'd have to go back and look at when we submitted a proposal.
Summer of 18 is fine. And at that time, they asked you, what did they ask you to do?
Submit a proposal to provide relocation advisory services and relocation assistance services.
Okay. On behalf of the city,
On
right?
behalf of the city.
Okay. And then you
If
got
the
a,
project went forward.
okay, and you got approved on August 30th, 2018?
I believe that's the right thing.
Okay. And at that point, you were under contract with the city, and what did you do next?
Attempted to contact the Stigmatines to get onto the property, to do an initial interview, to find out the lay of the land and what was there. Okay?
And how did you try to get the phone number?
Through the website, and it turned out the number on the website rang busy over 50 times. Eventually, when I was on the site, I was told the person who was responsible for the Stigmatine website left because of non-payment and walked away and didn't give anybody any information. Eventually, on a Google search, because I had seen Father White's name on some document, I was able to find that Father White, who was the president of the Stigmatines, is also the pastor of a church out in Springfield. I attempted to contact Father White and was eventually advised to go through Attorney Flynn, who was representing the Stigmatines. This was as a result of making a site visit to the property and being told that I could not be given Father White's number, and that's how I went on Google and found him.
Okay, did you ever try to contact Attorney Savone to get the number?
No,
He hired you, right?
I'm an independent person, Peter.
Okay.
I take my assignments
Okay.
and follow through and do the work.
All right, then subsequent, all right, so with the website you told us, and then when did you first meet with me on the site?
That was after, I believe, that you and I and Father White met in the provincial house, and I think that may have been December,
Okay,
okay?
Yeah.
And I think after that, it may have been early January because it was cold. You and I walked the site, walked the buildings.
and you've been in the courtroom since this morning, right?
I have
So you know who Jessica is and Joe DeSia?
Jessica and Joe DeSia have been our guides, I'm gonna say, when we have been on site. They have opened up doors for us. They have, Joe was down in St. Joseph's Hall, Jessica was at the retreat house, and Jessica also goes down to the provincial house.
Mr. McFarland, would you say in terms of what you're trying to do, relocation, that my office was also cooperative?
Yes, the issue is, Peter, we are
Just
unable.
just because we're in a formal environment, I'm going to ask everybody to do the
Well-
same thing, which is I know you know each other, but we refer to everybody by their last name out
Okay.
of respect and court.
No, just as to, I was cooperative, right?
Correct.
All right, I'll get you to where you're trying to go. All right, so, did you inspect all the buildings?
I have gone through all the buildings.
And have you done it?
And our initial purpose was to conduct an inventory of personal property and look to see if there were any issues of realty versus personality in those properties that we were told were occupied. Those properties being St. Joseph's Hall, the Provincial House, the gift shop as part of the Provincial House, and the Retreat Center.
Okay, now you've discovered beyond the priest, there's a woman that lives at the retreat center as well, right?
We were told that Maureen, I believe her first name is,
Yeah.
lives there, yes.
Okay.
And we have seen her accommodations.
All right, and you have assembled all the inventory with respect to the property?
We have an inventory of the personal property in those 3 buildings, okay? We have not done the exteriors yet.
So, how many months have you been working on this relocation project?
Well, this is one of about 6 projects we're working on, so we're not devoted full-time to it. I believe our first access was sometime around February, and it's a tedious job.
There's a lot of personal property
A
there,
lot
isn't
of
there?
personal property there, and we go back and verify everything that we have done.
And there's enormous statues out on the vacant land as well, right?
No statues there.
And do you take that into consideration in your relocation estimates?
The first thing we're attempting to do, Attorney Flynn, is ascertain who was in residence on July 23rd, 2018, which is the recording of the order of taking. That is the date. That is the date that triggers relocation for those people who were in permanent residence as of that date, okay? The only person we've been able to ascertain as being a permanent resident has been the resident at the retreat center. We cannot and have not been able to ascertain who were the permanent residents under the definition of dwelling under 760 CMR, which is one's place of normal and permanent residence.
Okay. Now, even though you've had trouble with the number of residents and things like that, have you completed your inventory on the interior of the buildings?
We have completed the inventory on those 3 buildings.
What about the other buildings?
We have not.
All right, how many more months is it going to take for you to finish up your relocation study?
Well, on the vacant buildings, we'll just walk through, take pictures and document. On the outside with the statues and that, we'll just take pictures. The determination as to what happens to the personal property is the determination of the displacees. They have to determine what they want to do with it, okay?
Yep, and as part of your job assignment, do you have to seek out brokers and seek assistance in finding comparable locations?
I'm going to come back to my other statement. In order to determine who is eligible for residential relocation assistance, we have to determine, and we cannot determine, and have not been provided the information as to who was a permanent resident at St. Joseph's Hall as of July 23rd, 2018.
Okay.
Because we get back to that, how many people or businesses are being displaced? If it's more than 5, relocation plan. Less than 5, I've never seen a relocation plan done.
Okay, but you have to still relocate even if it was
You
less
still
than...
have to relocate, but you
Right.
have to know who you're gonna relocate.
Assuming eligibility, Mr. McFarland, right? How much longer is it going to take you to completely plan?
How much longer is it gonna take me to get an answer as to who was a permanent resident as of July 23rd, 2018?
Have you asked the city?
We're not displacing the city. As I
I'm sure,
told
no, if
Father-
you ask the attorney.
As I told Father White,
Yeah,
okay, we're displacing the Stigmatines.
all right, the
Okay? That's who I asked the question to.
Father-
And you, as their attorney, is who I asked the question to.
all right, Father White gave you some answers to that at our meeting, did he not?
He told me he needed space for 16 people.
Okay, and,
I
I
said,
got you.
who?
okay, I got you, we'll get to that. All right, as far as access though, to the property, you've had no problems,
Look
basically?
at access, man, go on.
All right. I have no further question.
May I ask a question, Your Honor?
No, one attorney per side.
Can we have a moment, please?
Sure.
Thank you.
What's this exhibit? Mr. McPowen, I've been informed.
Counsel, could you show it to the other
May
side?
I approach your honor?
Other side first.
Yes, as long as the other side's seen what you're.
It's not a marked exhibit yet, Your Honor. Mr. Savone has it, but it's been the subject of dispute.
Okay, thank you.
But that door may now be open.
I mean, just its own language, I'm going to object.
Your honor, may I show it to Mr.
Yes.
McPowen? Mr. McPowen? This is a document, defendant's supplemental responses to city's first request for admissions. Have you ever seen that?
I do not believe I have. What's the date on
March 2019. You've never seen this?
No.
You remember talking about that, the components of this with me and Father White in this conference room? I'd offer this, Your Honor, as an exhibit.
Any objection?
Yes, Your Honor.
Is Father White on that
Just one
list?
second, just 1 second. Let's do this, to save the time, what we'll do is when we take our lunch break, which is gonna be just in a few minutes anyway, we'll talk about that and see whether that's coming in evidence, but let's just keep going with this witness.
I don't think you have any questions.
I have no further questions.
Okay, and we'll reserve on that, prosecutor.
Mr. McFarland, at a couple of times during the direct examination by Attorney Flynn, you seem to have wanted to complete your answers about something. And I want to direct your attention to, I think one of the points had to do with trying to get an answer about who was permanently and regularly in residence at the St. Joseph's Hall. Do you remember that?
Yes.
Did you ever get any specific answers about who was permanently and regularly residing in St. Joseph's Hall?
I'm asking the same question under oath.
I'm sorry?
I'm asking the same question under oath.
Right. So did you ever get it? Okay, let me ask it this way. Who did you ask that question to?
I asked it to Father White and Attorney Flynn at our meeting in the conference room in the Provincial Center. I believe it was in December.
Were you given any specific people who were permanently and regularly in residence?
I received no names at that time.
And going back to, you seem to be very specific, and I think you cited either a part of the statute or a CMR about the definitions of what determines who is an actual person who is a resident on the date of taking. What were those requirements?
The definition under the Mass Regs is that dwelling is one's permanent place of residence.
And
And that is as of the date, the recording of the order of taking, that date.
were there ever attempts by you to have meetings, strike that please, in all of these other relocation situations that you had talked about with Attorney Flynn, is it normal custom and practice to speak directly to the people who are supposed to be the residents of a property who are going to be displaced?
Representing a taken agency, you would interview the displacees, whether they be owner occupants, residents, in this case, in order of religious, under the vow of obedience, okay? And we look at that as like one family, not 5 or 6 or 12 or 16 displacees, because being part of a religious order under the vow of obedience, you will go where the Superior General or the President tells you, this is where we're gonna live. We're not displacing individuals, we're displacing the residents of St. Joseph's Hall.
And were you ever prevented or told that you could not speak directly to those residents?
We were asked not to engage staff or anyone on site. Our point of contact would be Attorney Flynn, would meet us there, and then would turn us over to Jessica at the Retreat House or the Provincial House, or Joe DeZia at St. Joseph's Hall. And then we were on our own, but we honored that request not to engage people.
When you say not to engage, you mean not to speak?
Not to engage in conversation, like how long you been here, where you want to go.
So it sounds like that makes it pretty difficult for you to do your job of determining who was in residence on the date of taking if you were
Objection.
told.
Why don't you rephrase it?
Can you tell us, and maybe it's something you've already testified to, how you go about determining who was truly a permanent resident in St. Joseph's Hall if you're not allowed to talk to the people who might be in residence there?
Well, normally we'd say, do you have a lease? Well, in this situation, there's no lease. Are you a registered voter? We would go to the town hall or the city hall and pull the census to see if we can get a census to who is a resident under the normal means of testing residents. Do you have a driver's license? I mean, that shows Lexington Street has that point. Or are you a registered voter in Springfield?
And were you told that you couldn't get any information except through Attorney Flynn and Father White?
I was directed my first conversation with Father White to go through Attorney Flynn, and we have honored that. When we met, access was granted by going to Attorney Flynn, and he's responded.
So it sounds like you've never been able to actually even speak and get direct information like you've been looking for through Father White, is that correct?
Father White told me to get back to me, and I understand he's been sick.
And have there been problems with getting things done quickly because of where Father White lives?
As far as access, no.
Okay. But in terms of meetings, where does you understand that Father White lives?
My understanding is Father White lives in Springfield, and I think it's Our Lady of Mount Carmel, where he is the pastor and the rector.
The only other thing I think I heard you say it correctly. I think I heard Mr. Mollica say that a relocation plan is required when there's 5 or more.
More than 5.
But it's correct, the
More than
statute's
five
more than
is the
5, so it's really
terminology.
6.
Yeah.
It's not 5.
The regulations say more than 5.
Thank you, no further questions.
Just have one, Your Honor.
Yes.
May I approach?
Yes, you may.
This is already a marked exhibit. You just talked about the census. Did you ever see this, about the census? This is a letter to the city council from the mayor.
Could you give me the number of the exhibit, please?
It's number exhibit 19.
Thank you.
The See this? Mayor reporting that. Could you read that to the court? Number one.
Stigmatine
Excuse me,
fathers.
what's the date of that letter?
That's the February 2017.
2017,
That's
February.
before my time.
No, I know. Just read number one.
Well,
Oh, no, he
object on
mentioned the
relevancy.
census.
Just one second. He did mention the census. I do have the exhibit, so if you're going to be asking him a question, then I think what we should do is come back after lunch. But if it's just to show me what's here, I do have it in front of me.
Can I have him just read that, number one?
Sure.
Read
I'll
just
do
number
that.
one.
Okay.
Stigmatine fathers census indicate there are 8 residents on site. They use rent-free but pay their own utilities and expenses. The Tony Hall, St. Joseph's Hall, Chapel, St. Mary's Hall, St. Anne's Hall, and the shed until the said stigmatine fathers find alternative living quarters. See attached description of 6 of the 7 buildings.
Thank you. Finally, Mr. McFarland, you remember our meeting with Father White, right? You don't remember him discussing the names of multiple priests?
At this point, I don't.
Okay, thank you.
Okay, all right, so can we let this witness go?
Yes, sir.
All right, thank you very much. You may step down. What we'll do is let's come back at 2, and why don't we pick up with the.
All rise, please. Good afternoon. You may be seated. Court is now in session.
And Your Honor, we're back on the record on hearing 18 CV 2385. Could parties identify themselves again for the record? Please.
For plaintiff, City of Waltham, Attorney John Cerrone, City Solicitor.
For defendants, Stigmatine fathers Jason Scopel and Peter Flynn.
Thank you.
All right.
Did you want to do the document first that we left on?
Yes, why don't we do that?
I think we have a series of answers to interrogatories, responses to requests for admissions. I frankly assumed that this one would go in for the same reasons, but my brother has an objection.
Okay, yes, let's hear the
Well,
objection.
it's fairly direct. Is the rules under MRCP 36, they'd already filed and admitted the requested admission. What I see proposed is, we don't like the way you phrased your admission. We want to admit something else with no dates. And as I read this, they're saying that as the stigmatines define things, at various dates and times, there were many more people. And I don't know if you have it.
I have seen that already because I believe it was attached to one of the previous motions that I had because I know
It
that
is
I've already
attached
reviewed it.
to a discovery motion.
And I understand the limitations of it. What I'm going to do is I'll accept it as an exhibit, but I'll understand the limitations of it because this is all so specific to particular dates. I'll decide what weight to give it. I'll accept it as an exhibit for this purpose.
Thank you, Your Honor.
So is that marked or not marked?
I don't believe it was, so here.
Okay. So is it 29?
I believe so.
Okay.
Right, 29.
I lost track.
Exhibit 29, so marked, Your Honor?
Thank you. Okay, you may proceed.
Thank you, Ron. With Mollica, at least I'll just get right into it. For example, if myself and my law school buddies while we're in law school rent a nice big house, 6 bedrooms, bathrooms, but we all live together, share main big common rooms and a big kitchen. That's one dwelling unit, correct?
Well, for the purposes of the benefits, you'd each be eligible.
Right, we would each have to share the benefits that are assigned to that one dwelling unit, correct?
But you're displacing from, the dwelling unit would be what you're living in.
Yes, but my point is, I understand what you're saying is, if there are, let's say there's 8, 10, it doesn't matter how many people,
Right.
but the people who are displaced from that one dwelling unit share in the benefits, the relocation benefit payment that's assigned for that one dwelling unit, correct?
They would share the benefit.
Yes.
If we were preparing, say, a plan, we would make note of each occupant.
Right.
Right.
But each document doesn't count as a separate dwelling unit, correct?
In the case of a bunch of people living in one house, no.
Thank you. And I want to ask, I want to go right to something, just to make sure I understand it. And I'm going back over something, and I think you were going building by building. And I understood your testimony to be that the espousal center was one business.
It would seem that way, yeah.
And the provincial house was one business.
I would view it that way.
And I think you said, even though the espousal center business had a caretaker for that business that lived in that business, you looked at that as two separate units.
I would say she's living in a separate unit where she lives within the business, right?
But she's tied
It
to
would
that
kind of-
business.
Right, I mean, it would be like if, you had a business and someone lived upstairs.
Okay.
It wouldn't be that unusual, and that would be true. The business and the person living there.
So, again, counting up what you're talking about, if I accept what you're saying, you have the espousal center plus the caretaker, you're saying that's like two separate units.
Right.
Even though it's the same building.
Yeah,
And then you're saying the provincial house is another unit,
I would say
so that's three.
that's 3.
And then the only other building that's occupied is St. Joseph's. And you said that there were, I think, let me ask you this. You were counting the individual priests as separate dwelling units, correct?
They're in separate dwelling units in the St. Joseph's house, yes.
Well, you're meaning they're in separate bedrooms.
No, I mean, it's set up in such a way where I would call each one of those dwelling units their dwelling.
So a bedroom is a dwelling unit, as far as your
I
interpretation.
believe some of them may have a kitchen facility or a little kitchenette. I don't know if that makes an entirely big difference. There is a lot of latitude in the regulations with how you would make that determination. They say, it's a custom and unusual place of dwelling, so it doesn't mandate that there be a particular feature to it.
No, I'm talking about the definition of dwelling units.
A dwelling unit.
Not people, how they are using it. So let me ask you this question. Would it be fair to say that the St. Joseph's Residence Hall has one big communal facility for food preparation and dining?
It does.
And then it has separate bedrooms that may have a bathroom attached to it.
That's right.
And that is the basis for which you say those individual bedrooms are individual dwelling units, even though they share everything else communally.
I would say that, yes.
That's your interpretation.
Yes.
So if that's not accurate, then you do not have 6 total units on that site, do you?
It wouldn't seem that way, no. You would have to deal with each one of them as a dwelling unit, right?
And you heard Mr. McParland talk about exactly that issue. They are living together communally as one, like a single-family unit in a big house with multiple bedrooms.
I don't,
Did you
I
hear that, though?
Yeah, I
That's
did
what
hear
I'm
that, yes, I
okay.
did hear that.
And are you saying that your interpretation is different than his?
It is.
Okay. And by the way, I thought I heard you saying, you correct me if I'm wrong, I thought you said the jurisdictional number that activated the requirement in your opinion, for a relocation plan was 5 or more.
I misspoke. The
Okay.
79A says more than 5.
Okay, just, thank you. And there were some questions that Attorney Flynn asked you about who you talked to and who you didn't talk to. You remember that in direct, where you got your information? Do you remember that at all?
It was Attorney Scopa who was asking me, and I don't really recall
Okay.
that line of
Sorry.
question.
Okay. Did you ever speak to Mr. McParland to try to get any information at all about the actual permanent regular residents at the St. Joseph's Hall or anywhere else on the
Yeah,
property?
no, it wouldn't be my role to talk with him,
Talk to who?
Mr. McFarland.
But you didn't.
I didn't.
So, and did you talk to anyone from the city about whether they had information about any aspect of who was living or how that property had been used or not used?
No.
And did you speak to anyone other than Attorney Flynn's office about that?
I did do an inspection of the property and
Okay.
did speak with the priests who were living in St. Joseph's house.
Oh, so you were allowed to speak to the priests who were living in St. Joseph's house directly?
Yes,
And that would be a normal thing to do?
I didn't see it as anything but.
Right. So you had nothing, no gatekeeper telling you who you could or could not speak with in terms of doing your relocation work, correct?
On that day, no.
You also indicated that anyone who is aggrieved of anything that happens under Chapter 79A can go to the Bureau of Relocation, is that correct?
No. If they're aggrieved by specific matters, they can.
Right.
Basis to be aggrieved and pursue a hearing before the Relocation Bureau is limited to a determination as to eligibility for benefits or determination as to whether we are displaced.
And you disagree with Mr. McFarland's recitation of the CMRs in the statute that the time in which you determine eligibility as a resident of a dwelling unit is based on or at or around the date of the recording of the taking?
Yeah, he's incorrect about that.
Is incorrect. So if the taking occurred on July 23rd, are you saying that people could come in after that and claim benefits?
No, I'm not saying after that.
Okay. So if they weren't actually living there, within a month or two of the date of the taking, are you saying someone can still claim benefits under the Relocation Act?
The triggering event for determining if a person is eligible for relocation assistance depends upon their occupancy of a property that's to be acquired at either the date of the taking or the date of initiation of negotiations for the property. So if there was a lawful occupant on the premises at the date of initiation of negotiations, that person would be eligible for benefits. There could be a period of time between the initiation of negotiations and the recording of the taking. Anyone who was on the property and then moved out after initiation of negotiations would be eligible.
If they moved out?
If they moved out, of course.
Thanks. Madam, I was wondering if I could have Exhibit 11.
Yes, from the original exhibits.
Thank you. Did anyone from the Stigmatines who you spoke with or Attorney Flynn's office ever tell you that for all of the years preceding the taking, that the Stigmatines had refused to consider any relocation off the site?
No.
Did you look at any or ask for any of the documentation regarding what may or have been offered for relocation of the site?
No.
Did anyone from the Stigmatines tell you that the city had offered the Marquardt building once it was at the Fernal State School, once it was left by the state of Massachusetts, which is you aware of that? Anyone talk about that?
No, but if there's that sort of facility, that would be, sounds promising, something to put in a plan.
And were you familiar with any other church-type facilities in Waltham that were available for rent?
No.
Did anyone from the Stigmatines or their attorneys tell you that it had been offered or suggested that the St. Charles Borromeo Church on Movie Street in Waltham, which was closed by the Archdiocese, had at least 10 units for priests that had been recently renovated and were available for rent?
No, but that sounds promising.
Well, just take a look at that. So as you said, that would sound, either of those options would sound promising as a offered relocation for someone being displaced.
I couldn't speak from the basis of this letter whether or not those properties would be considered to meet the standard of functionally equivalent and comparable. But if they were preparing a plan, that would certainly be a basis to start in terms of possible replacement locations.
Did anyone from the Stigmatines tell you that there were numerous attempts to try to discuss relocation with them, and they refused to consider anything but remaining on the site?
I wasn't told that.
Thank you. No further questions.
One question, Your Honor.
Yes.
Fair to say, Mr. Mollica, even if it were determined somehow that the occupants of only, let's say, 1 or 2 units were being displaced because of this taking, those occupants are entitled to relocation assistance that has yet to be provided to this date.
That's correct.
And under the statute, they cannot be displaced until that assistance is provided.
Objection, Your Honor.
Overruled.
That's correct.
Thank you.
Okay, thank you. You may sit down. Okay, anything further from the Stigmatine fathers?
Not today, Your Honor. I believe the next witness, which may be the last witness, Father White, will be tomorrow,
Okay. all right.
consistent with the court's schedule.
Okay, and so tomorrow morning, would you like to start at 9 o'clock?
Sure.
Okay, and is that acceptable?
That's fine.
Tomorrow?
Yep,
Okay.
thank you.
All right, so what we'll do is we'll pause at this point, and I will go to the rest of the afternoon list, and we will resume this case tomorrow at 9 a.m.
And I assume it will be the court's preference to do any other housekeeping issues we may have tomorrow, not right now.
That would be right.
Yes, okay.
Yes, happy to do that.
Thank you.
Okay, thank you very much.
Thank you, Your Honor.
Okay, thank you.
Your Honor, would you like to put it back?
Yes.